Would like to take this opportunity to introduce Sam. He is a partner in SG Civic Planning, which is a consulting firm focused on work with local governments and developers across Wisconsin and Minnesota. Prior to that, he served as the publisher of Fulcrum Publishing, a leading independent book publisher, for over 15 years. He received his Juris Doctorate from the University of Denver and worked as a public finance attorney prior to joining Fulcrum. In 2015, Sam founded I Am Education, a nonprofit focusing on critical thinking and civil discourse within education. He is a lecturer in the Servant Leadership Program at Viterbo, where he teaches a class on civics and the common good, and the Political Science Department at UWL. In 2021, in partnership with Viterbo University's Reinhardt Institute for Ethics and Leadership, Sam created Rebuilding American Civics, a program designed to provide civics education and creating a space for civil discourse. This program launched a new series, Civics and Cinema, in the fall of 2024. He's served in several boards in the Western Wisconsin region. Now, Sam is going to do a conversation, so you must remember that we are recording this, that there are people online. So if you want to speak, please raise your hand and I will come over with a microphone so we all can hear, people online can hear, and it'll be recorded. So that's our only request, and I will let Sam begin our conversation. Thank you for Thank you for doing the quiz, and raise your hand, please, when you need me.
Thank you so much, Deb. It's great to see everybody today. Welcome on a wonderful chilly day in La Crosse. I'm so honored to be here because the work that you do as the League is just so phenomenal and so central to our democratic republic. My focus area in political science is on political thought and the legal process, although I've done a lot of courses as well on American government. And when you talk about legal thought, you think about this idea of democratic theory, representation, and the whole idea of what it means to live in a democratic republic, which the United States is. And when you think about the democratic republic, two of the key fundamental parts, as former Senator Gary Hart articulated in his recent book, The American Republic Can Save American Democracy, is democratic republics are conditioned on the idea that there is popular sovereignty through representation. That is the work you are doing, this popular sovereignty. That means getting people to participate in our representative government. And then the whole idea of civic virtue, which is this notion that citizens have both rights and responsibilities in a republic. And the baseline responsibility that we have in our democratic republic is to participate through voting. And so the League is obviously right on the front lines of doing that, of expanding suffrage, of getting people the information they need to vote, which is so important and central to this, but also trying so hard to make sure that everybody who has the right to vote can actually vote. And we do this really, really well here in La Crosse. So you must be doing something right, because I don't see too many communities that had 98.1% of turnout in the most recent election. So kudos to you and to everybody who is getting out the word to participate. Here's the bonus question. This was actually something I learned, I had not known. One of the 13 original states actually allowed women to vote from 1787 until 1807. Which state was that? Rhode Island, I heard. White women. Georgia, Pennsylvania. Nope, none of those. Delaware, Maine, nope. You're working your way through the 13. New York, nope. New Hampshire, nope. New Jersey, who said New Jersey? It was New Jersey, yes, New Jersey. Actually, and I learned that from the National League of Women Voters website. I did not know that before pulling something together. I actually used it as a quiz question in one of my classes this semester, and the students proceeded to name every one of the colonies, and now states, until they got to New Jersey. So it was the 13th one that they mentioned. But I took great pride in the fact that they knew all 13 of the original states collectively as a group of students. So you'll recall Martin Luther King had that wonderful quote where he was paraphrasing a Unitarian minister, this whole idea that the arc of history bends toward justice. Well, I like to look at American history in a similar way. The arc of American history has bent toward suffrage, has bent toward this opportunity for more people to participate. Obviously, when the nation is founded in 1776, when we create the Constitution in 1787, that meant one thing. For the most part, it meant white men who owned property. But we see this evolving over time. And so what I want to just do is walk through initially and just, again, kind of gauge your knowledge here of what some of these dates mean in terms of bending toward that arc of suffrage in the United States. So 1787, we create the Constitution. How about 1870? What happens in 1870? Well, Reconstruction's happening, but what with respect to voting? 13th, 14th, 15th Amendments. Yes, we finally allow for all males to vote regardless of race. So these collective civil rights amendments, the 13th, which ends slavery, the 14th, which creates the Equal Protection Clause, and then the 15th Amendment, which grants suffrage to all males in the United States. Now, of course, we know that things didn't go great in the South particularly, but at least constitutionally, that was a protected right. What about 1913? What happens in 1913 with respect to suffrage? So 1913, we pass the 17th Amendment to the Constitution, which it grants direct election of U.S. senators from citizens. Important to remember that for the first 130 years of the Republic, only one part of one branch of government allowed for direct election, and that was the House of Representatives. In 1913, we add the Senate to that. And so since then, we've had one branch of government that has direct election from the people. Of course, the president is not directly elected. That is through the Electoral College, and the Supreme Court has absolutely no tie whatsoever to how we vote, other than they get to select the members of the court. 1920, this is an easy one. You know this one. That's the 19th Amendment, right? So finally, here we are, 133 years after the Republic is founded, that women now have the right to vote. 1964, and 1964, we have the 24th Amendment, which eliminates the poll tax. What about 1971? Yes, absolutely. 1971, the right of citizens to vote who are 18 years or older. So one of the things I like to talk about when we talk about my students, when we talk about democratic theories, I say, well, when did America become a democracy? Because we all peg it to 1776. But one could make the argument that the true moment America really became a democracy was in 1965, with the passage of the Voting Rights Act, which we are celebrating here today. So this Voting Rights Act, the idea for a Voting Rights Act was there in the ether. People were talking about it. But it took an incredible moment in history for this to actually come to fruition. On March 7th of 1965, 800 peaceful marchers crossed the Edmund Pettus Bridge in Selma, Alabama, whereupon these marchers, who are marching hand in hand, they were singing, they were praying, were tear gassed and beaten by police officers with whips and batons. One minister was killed. John Lewis, who went on to become a U.S. representative, was brutally bludgeoned during the march in what became known as Bloody Sunday. The footage of this act of civil disobedience and the response to civil disobedience, not one of the protesters raised their arms, raised their fists against this beating, shocked the nation. Still images taken in newspapers, but more importantly, moving images. The power, and we have Rusty here, of course, the power of journalists, and the media to convey this to people really brought it home to our elected officials that something needed to be done. Lyndon Baines Johnson watched aghast as this was happening. And 8 days later, Lyndon Johnson gave a speech to Congress calling on Congress to pass something like the Voting Rights Act. I'm going to read to you some of his speech that he gave on March 15th of 1865. This is Lyndon Johnson. At times, history and fate meet at a single time in a single place to shape a turning point in man's unending search for freedom. So it was at Lexington and Concord. So it was a century ago at Appomattox. So it was last week in Selma, Alabama. There, long-suffering men and women peacefully protested the denial of their rights as Americans. Many were brutally assaulted. One good man, a man of God, was killed. There is no cause for pride in what has happened in Selma. There is no cause for self-satisfaction in the long denial of equal rights of millions of Americans. But there is cause for hope and for faith in our democracy and what is happening here tonight. For the cries of pain and the hymns and protests of the oppressed peoples has summoned into convocation all of the majesty of this great government, the government of the greatest nation on earth. Our mission at once is to serve the oldest and most basic of this country, to right wrong, to do justice, to serve man. There is no Negro problem. There is no Southern problem. There is no Northern problem. There is only an American problem. And we are met here tonight as Americans, not as Democrats or Republicans. We're met here as Americans to solve this problem. This was the first nation in the history of the world to be founded with a purpose. The great phrases of that purpose still sound in every American heart, North and South. All men are created equal. Government by the consent of the governed. Give me liberty or give me death. And those are not just clever words, and those are not just empty theories. Those words are promised to every citizen that he shall share in the dignity of man. This dignity cannot be found in man's possessions. It cannot be found in his power or in his position. It really rests on the right to be treated as a man equal in opportunity to all others. Our fathers believed that this noble view of the rights of man was to flourish. It must be rooted in democracy. The most basic of all was the right to choose your own leaders. The history of this country in large measure is the history of the expansion of that right to all of our people. Many of the issues of civil rights are very complex and most difficult, but about this there can and should be no argument. Every American citizen must have an equal right to vote. Just amazing. I mean, when you consider who Lyndon Johnson was, a politician for Texas who was not constitutionally inclined to fight for this, but the moment called for it, and Johnson rose to the moment. I had the great opportunity of befriending Gene McCarthy toward the end of his life. I worked with Gene for the last 4 years of his life on a book, got to attend his memorial service with his family. Gene told me that when Johnson was preparing this, he pulled in a couple of Democratic senators, including Gene, and sat them down and said, this is the right thing to do, and we're going to lose the South as a result. And the legislative process bore that out. The bill was introduced in the Senate on March 17th of 1965, 10 days after the March on Selma. 10 days after this event, Congress acted. Think about that. Think about that. Reflect on that and where we are today. 10 days after this happened, Congress acted. The bill was introduced. Johnson and other top Democrats knew that the Southern Democratic Dixiecrats would likely filibuster the bill, and so they had to get broad Senate support. Johnson, ever the legislator, enlisted Everett Dirksen from Illinois, the Republican leader of the Senate, to gather this support. Dirksen was initially, like Johnson, reluctant to support the Voting Rights Act, especially so soon after the Civil Rights Act of 1964 had passed. But he, like Johnson, was also moved by the Bloody Sunday footage, the power of the media and what it can do to move people. 64 senators co-sponsored this bill, and the Senate voted 70-30 for cloture, which basically ends the filibuster debate, and it passed 77-19 in the US Senate. The only opposition was from Southern senators, including 16 Democrats. The House passed this bill in July with a 333-85 vote, and this 85 included 61 Democrats. I emphasize those points again because we all have to understand the complexity of party. These issues are not about party politics. These issues, as Johnson identified, are about American issues. The act was signed into law on August 6th of 1965. What's that, 4 months after Bloody Sunday? Just astounding what you can do when you have legislative will, when you have the power to move forward and to do something. Congress actually can act. So what does the Voting Rights Act do? Well, Section 2 articulates the following, and I'm going to be reading a lot of direct quotes here, so just bear with me, because I think the language is very important. So Section 2, no voting qualification or prerequisite to voting or standard practice or procedure shall be imposed or applied by any state or political subdivision to deny or abridge the right of any citizen of the United States to vote on account of race or color. Now, this is merely putting into statute what the Constitution already had articulated, right? That all people at this point, theoretically, constitutionally had the right to vote. And yet we knew in the South the pernicious Jim Crow laws were set up to block people of color from actually participating. And these things were legally sanctioned laws of cities, of counties, of states. This was a legal framework that this Voting Rights Act of 1965 removed. According to Ari Berman, author of Give Us the Ballot, The Modern Struggle for Voting Rights in America, perhaps the best recent book on the Voting Rights Act, it effectively, in his words, prohibits voting changes and procedures that lead to the denial or dilution of voting rights for minority voters. It can be used to challenge discriminatory voting laws. It can also be used to challenge discriminatory election maps. And it applies nationwide. Any minority group can file a lawsuit under Section 2 to enforce the Voting Rights Act. That was the intention of the act. Of course, we will see in subsequent history it became complicated. The act notably created a pre-clearance requirement for certain jurisdictions with a history of egregious disenfranchisement of voters to obtain approval from either the United States Department of Justice or the U.S. District Court in D.C. before they would be allowed to make changes in voting practices or procedures. Imagine that. These states were such bad actors that to change anything in their voting policies, they had to ask permission of the federal government to change. This was part of the Voting Rights Act. This was the teeth of this Voting Rights Act. They had to prove that the proposed changes did not deny or infringe on the right to vote on account of race or color. The act, in turn, established a formula to identify those areas and to provide for more stringent remedies where appropriate. The first of these remedies was a 5-year suspension of a test or device, such as a literacy test, as a prerequisite to register to vote. The second was a requirement for review. The following jurisdictions thus came under review under this pre-clearance requirement: Alabama, Alaska, Georgia, Louisiana, Mississippi, South Carolina, and Virginia. In addition, certain political subdivisions, counties, cities of 4 other states, Arizona, Hawaii, Idaho, and North Carolina, also were covered. In fully covered states, the state itself and all political subdivisions of the state were subject to the special provisions. In partially covered states, the provisions only applied to the identified counties. In 1970, this part of the Voting Rights Act was renewed, and the baseline date of examination changed to the 1968 election as the baseline. This resulted in turn in partial coverage in 10 states, including Alaska, Arizona, California, Connecticut, Idaho, Maine, Massachusetts, New Hampshire, New York, and Wyoming. So what are we seeing here? This wasn't just a Southern problem. This was a national problem. Again, Johnson's prophetic words. Half of these states, Connecticut, Idaho, Maine, Massachusetts, and Wyoming, successfully filed for bailout lawsuits. So they were able to prove that while there seemed to be some facially apparent discrimination, they were able to show that it wasn't. Okay, back to the Voting Rights Act of 1965. Section 10 reads as follows. The Congress finds the requirement of the payment of a poll tax as a precondition to voting. One, precludes persons of limited means from voting or imposes unreasonable financial hardship upon such persons as a precondition to their exercise of the franchise. Two, does not bear a reasonable relationship to any legitimate state interest in the conduct of elections, legally meaning the states just really have no leg to stand on to do this. And three, in some areas has the purpose or effect of denying persons the right to vote because of race or color. Upon the basis of these findings, Congress declares that the constitutional right of citizens to vote is denied or abridged in some areas by the requirement of the payment of a poll tax as a precondition to voting. So this happens in the 1965 Voting Rights Act. The 24th Amendment to our Constitution articulates that as a constitutional right. The right of citizens of the United States to vote in any primary or other election for President of the United States, this is how the 24th Amendment reads, for electors for President or Vice President or for Senator or Representative in Congress shall not be denied or abridged by the United States or any state by failure to pay any poll tax or other tax. And this, in turn, was strengthened by the landmark case of Harper versus the Virginia State Board of Elections in 1966 to extend to all elections, not just federal elections. So what's fascinating, you see this in other areas of American government as well, is Congress acts, but then sometimes the Supreme Court also acts to add color to what the Supreme Court has already done, or to what Congress has already done, right, to flesh some of this out. Back to the Voting Rights Act, Section 11B. No person, whether acting under color of law or otherwise, shall intimidate, threaten, or coerce, or attempt to intimidate, threaten, or coerce any person for voting, and attempting to vote, or intimidate, threaten, or coerce, or attempt to intimidate, threaten, or coerce any person for urging or aiding any person to vote or attempt to vote. So we hear this all the time in elections, right, that you can't have voter intimidation. It is grounded in this 1965 Voting Rights Act. Later provides, this particular section later provides for federal election examiners and observers for certain jurisdictions where there is evidence of attempts to intimidate minority voters at the polls. Section 11C of the Act. Whoever knowingly or willfully gives false information as to his name, address, or period of residence in the voting district for the purposes of establishing his eligibility to register or vote, or conspires with another individual for the purpose of encouraging his false registration to vote or illegal voting, or pays or offers to pay or accepts payment either for registration to vote or for voting, shall be fined not more than $10,000 or imprisoned not more than 5 years, or both. So we hear a lot about protecting against voter fraud. Again, this is grounded in our National Voting Rights Act. This act has teeth, and it changes the landscape. By 1975, the Act's provisions were extended for another 7 years and were broadened to address voting discrimination against members of language minority groups, which were defined as persons who are American Indian, Asian American, Alaskan Natives, or of Spanish heritage. 4E from the original statute read that it was necessary to prohibit the states from conditioning the right to vote of such persons on the ability to read, write, or understand or interpret any matter in the English language. We broadened that in 1975. We make this more accessible to more people. America does not have a national language, right? Our nationalism is grounded more in our civic identity and our civic values. We don't have a national language. The Act recognizes this. Congress in the 1975 Act, starting in 1972, expanded the coverage formula based on the presence of tests or devices or levels of voter registration and participation as effective as of November of 1972. And this bailout provision that allows states to question the pre-clearance was amended in 1982 so that jurisdictions could meet the statutory standards that they could obtain relief. This amendment, which took effect on August 5th, 1984, established an objective measure to determine whether a jurisdiction is entitled to bailout. So instead of having to go to court, we started creating these objective measures that states could try and prove that they did not belong to the bad actors requiring pre-clearance. Jurisdiction, for example, seeking bailout must seek a declaratory judgment from a 3-judge panel in the United States District Court. In 2009, the Supreme Court held that any jurisdiction currently required to make Section 5 submissions could seek to bail out from coverage if it met certain statutory criteria. And then in 1982 and 2006, those coverage tests for pre-clearance were extended for 25 years. So this is a remarkable piece of legislation. And what happens? Well, by the end of 1965, 250,000 new black voters had been registered, 1/3 by federal examiners. By the end of 1966, only 4 out of 13 southern states had fewer than 50% of all African Americans registered to vote. Black voter registration, for example, increased from 6.7% to 59.8% in the state of Mississippi. And the Voting Rights Act set a really high bar for discriminatory impacts of changes to election laws. This was a bipartisan bill. Johnson admitted himself they could not have done it without the Republican Party. This was Democrats and Republicans coming together to forge something that stood the test of time. So what happens after? Well, in 2013, the Supreme Court hears challenges to the Voting Rights Act. And in the case of Shelby versus Holder, it holds that the coverage formula and pre-clearance formula for the Voting Rights Act were outdated and thus unconstitutional. In effect, Shelby versus Holder eliminated the pre-clearance requirement, found this unconstitutional because, in the court's words, Congress's requirements must be justified by current burdens and needs. Justice John Roberts wrote in the majority opinion, "Our country has changed, and while any racial discrimination in voting is too much, Congress must ensure that the legislation it passes to remedy that problem speaks to current conditions." The tenor of the court in 2013 was this was all passé, that these were not issues that needed to be confronted any longer. Ruth Bader Ginsburg, in her dissent, wrote, "Voting discrimination still exists. No one doubts that. But the courts today terminate the remedy that proved to be best suited to block that discrimination. The Voting Rights Act of 1965 has worked to combat voting discrimination where other remedies have been tried and failed. Particularly effective is the VRA's requirement of federal preclearance for all changes to voting laws in the regions of the country with the most aggravated records of rank discrimination against minority voting rights." And remember, throughout this process, states across the country, jurisdictions across the country were found to be subject to these preclearance requirements. After Shelby versus Holder comes down, several states, including the state of Texas, within 24 hours of Shelby versus Holder, Alabama and North Carolina established new voter ID laws and other various statutes restricting poll hours, early voting, and pre- and same-day registration right after. Since the decision, 31 states have enacted 103 restrictive voting laws. In 2021, the court heard another challenge to the Voting Rights Act, the Brnovich versus the Democratic National Committee case. In the Brnovich decision, the Supreme Court made it more difficult to challenge discriminatory voting laws in the court by rewriting the law that applies to lawsuits under the Voting Rights Act of 1965. The subject of this case was 2 Arizona statutes, One state regulation would require out-of-precinct ballots to be entirely discarded, even votes for president, governor, or some other races in which the voter could have cast a ballot anywhere within the state. The other Arizona statute spoke to a criminal statute barring anyone but a voter's family member or caregiver from returning early ballots for another person, the ballot collection ban. And the Supreme Court in Brnovich basically said those two statutes are okay, but in the process, they also limited the ability for private citizens to seek remedy in posing any voting restriction acts. Interesting to look at briefs that were filed in support of keeping the Voting Rights Act intact. There was one brief that was filed with the support of 17 states' attorney generals across the country. Another brief that was co-signed by leaders of 250 corporations across the United States who believed that robust voting rights were integral to the American Republic. Even though the lower court had found the law discriminated against the two Arizona laws discriminated against certain racial minorities, the Supreme Court overturned the lower court, in part relying on, in its words, factors never before considered in these cases, such as whether a state provides more opportunities to vote now than most states did when Section 2 was last amended in 1982. According to the Brennan Center, and if you're not familiar with the Brennan Center, I'd recommend you check out their website. They do phenomenal work in terms of constitutional protections, civil liberties, and voting rights. According to the Brennan Center, this case effectively, in its words, made it more difficult to challenge discriminatory voting laws in court, tilting the playing field in favor of discriminatory states. That's where we are right now with respect to the law. The preclearance requirement has been clawed back, and the ability for people to sue has also been limited. So what has happened since then? Well, in 2021, the John Lewis Act, honoring John Lewis, our hero from Bloody Sunday, was proposed. This John Lewis Act passed the House of Representatives, but was not passed by the US Senate. In effect, died on the vine. But the John Lewis Act would have done the following: establish new criteria for determining which states and political subdivisions must obtain preclearance before changes to voting practices might take effect. This, in effect, was trying to modernize the 1965 preclearance requirements to a more contemporary standard. The recognition that, sure, times have changed, but that times necessarily didn't mean that everything had been wiped out. Under the act, a state and all of its political subdivisions would be subject to preclearance of voting changes for a 10-year period if one of the following was found. 15 or more voting rights violations occurred in the state during the previous 25 years. 10 or more violations occurred during the previous 25 years, at least one of which was committed by the state itself. Or 3 or more violations occurred during the previous 25 years and the state administers the elections. So trying to, again, restore an objective standard by which bad actors could be identified. A political subdivision or a separate unit would also be subject to preclearance for a 10-year period if 3 or more voting rights violations occurred there during the previous 25 years. And states and political subdivisions would have to notify the public of changes to voting practices. The law would have authorized the Department of Justice to require states or political subdivisions to provide certain documents or answers to questions for enforcing voting rights. It outlined the factors courts must consider when hearing challenges to voting practices, such as the extent of any history of official voting discrimination in the state or political subdivision. And it would allow for a voter to bring federal action for vote dilution when practices such as gerrymandered districts make it harder for candidates preferred by minority voters to win. In effect, it would push back against Brnovich. As I said, this passed by the House, but failed to get past the 60-vote threshold in the Senate, and so does not exist today as a potential act. Further court stuff that has happened since this time in 2023, the Eighth Circuit Court of Appeals ruled that under Section 2 of the Voting Rights Act, private individuals and private groups can't bring challenges to enforce that key part of the Voting Rights Act. Now, why does this matter? Well, the Brennan Center points out, the Department of Justice brings very few voting rights cases. If you look for the past 40 years, there have been 182 successful lawsuits filed under Section 2 of the Voting Rights Act. Only 15 were brought by the Attorney General of the United States, meaning that 90% of the successful lawsuits under the Voting Rights Act were brought by private groups and private plaintiffs. So the place where the most potential action happens has by and large been precluded by the federal courts. And in July of 2024, the U.S. federal court struck down a part of an Ohio House bill that made it a crime for all but a handful of family members to assist voters with disabilities in casting absentee ballots. The League of Women Voters of Ohio was behind the effort to overturn this particular bill. So that's where we are. We've got the Voting Rights Act. It is still intact. We've got some constitutional protections that flowed from that, but we also have a situation where many of the provisions of the Voting Rights Act have been clawed back, have been amended, have been narrowed to the point that we are today. Why does this sadden me? Well, go back to where we started. The fundamental parts of living in a democratic republic are popular sovereignty through representation and civic virtue as exhibited by citizen rights and responsibilities, the key to which is participating in our elections. It is in the interest of both political parties to maximize the ability for people to vote. We've seen this in the last election, right? We have seen voter turnout increase markedly. And I'm hoping at some point that both parties start recognizing that it is in the best interest, as Johnson did in 1965, for America to make sure that the ability to vote includes the least amount of hurdles possible. Now, this doesn't mean that we can't have good regulations with our election process. We talked about this a month ago when we were talking about what's happening here in the state of Wisconsin, right? Every state runs its elections differently. And we see that there are common sense provisions in many states in trying to minimize voter fraud, minimize opportunity for people to be bad actors in this process, but also trying to recognize that not everyone can show up on election day. The ability for people to participate in other ways in a monitored manner, making sure that people who are homebound can participate. Just as a mere example, right? Making sure that all voices can possibly be heard. Again, it is in the interest of both political parties. This is not a partisan issue. I think Johnson was absolutely right. It's an American issue. It's an American issue, and it goes to our fundamental core political values of who we are. Again, this is why I'm so proud to be here with a group that fights for this every single day of your organization's existence. And so I thank you for inviting me to talk about this history, and I'm happy to have a conversation on any questions you might have. And just like that, very quickly, a question.
So if the John, what's his name?
John Lewis Act.
Lewis,
Yep.
right. If that had been signed into law and it provided different levels of finding violations, is that always a court-driven process?
No, so basically you're setting an objective standard that you can measure, the Department of Justice could measure and see which states had violated. So it's looking backwards.
Right.
So what the John Lewis Act is providing is that history doesn't have to be fixed in time, that it can evolve and states can get better, but you're going to provide a looking backwards and saying, okay, within the last 25 years, if you've been a bad actor, perhaps there's a hurdle.
So what would it have been, the Department of Justice who made that determination?
Well, and
or
Congress.
The court?
No, it would not be the court. It would be
Okay,
this
okay.
would not be this would
Because I was just trying to
it would make
square.
a statutory thing. Now, obviously, it could be subject to people fighting it at courts, as has happened with the bailout provisions, right? So certain states would take that to federal court and say, we want to prove based on those standards, but that is going to then require marshaling evidence to show that indeed you had met those conditions.
But if the Supreme Court limits the people that can bring those actions, say there's no private right any longer, you're limiting how you would get to those standards.
Yeah, so here's the challenge, of course. any law that is passed by Congress is subject to Supreme Court review. So it is possible, although we will never know, right? It's unfortunately because we can't prove the hypothetical, but it is possible that the Supreme Court would have looked at this John Lewis Act as violative of the Shelby decision, and could have declared it unconstitutional, or could have declared parts of it unconstitutional as inconsistent with Shelby. Or it might have looked at that as a legislative response to Shelby and said, okay, because this is sometimes what the court is doing, right? The court is inviting Congress to say, this is unconstitutional as applied. Now go back to the drawing board and give us a law that might fit. And they might look at that new John Lewis Act and say, okay, this now makes sense and could be consistent with Shelby, or maybe parts of Shelby need to be overturned because this applies. But yeah, the Supreme Court still is going to hold some power with that.
Might you be able to reflect on our country's our democracy's commitment to voting as compared to other democracies? Australia comes to mind.
Sure. So in Australia, you are penalized if you do not participate, and this is a challenging one. You have to pay a fine, effectively. This is a challenging one for me because I'm also a believer in civil liberties, and I think one of the civil liberties has to be not necessarily being compelled to participate. The way I always talk about it with my students is to say, look, I understand you maybe hate everything on the ballot, or you think you do. Trust me, you don't if you really paid attention. There are things on there you would like. The best way for me to register that you don't like what's on the ballot is to go take a ballot and don't fill it out and turn it in, right? That to me is a protest vote. You are still participating and you're sending a much stronger message than sitting at home. Because when you sit at home, we don't know whether you're dissatisfied or you're tired or you're lazy or what have you. If you actually show up, say, this is my ballot, I don't like anybody, and I turn it in, that sends a message. And actually politicians pay attention to that. We've seen that in recent elections where politicians are obsessed with the differentials that they see in different races. Well, how come, this race was won by this many in this race? Well, it's because people are not voting in certain races because they don't like the candidates. Well, let me give you another example of this. And I apologize, this is a little bit of a gruesome story, but I think it shows the power of voting. So I have a friend here in town, Bob Van Wicklen, who's the director of advancement at Viterbo University. And Bob, I hope Bob's okay with me sharing this story. I think he is, because I've shared it with students as well. He used to be an aide in Congress. And so when he was an aide in Congress, he was sent at one point to Angola to observe elections there. This is not unusual for congressional aides, where they get an opportunity to go see, hey, this is the first time this country has been able to do free elections. And so we act as election observers. We see what's happening. He was there observing with a couple of his colleagues an election in Angola. He said he got there and there were these people from this village waiting in line very patiently to vote. First time they were able to vote. So Angola at this point, there had been a dictatorship, a coup, and then a counter coup, which established this democracy. Well, a guy shows up with a machine gun from the previous government to this voting area and fires the machine gun in the air, obviously attempting to do what? Intimidate those people who are participating in this election. The villagers scatter. They don't scatter out of fear. They go back to their homes and they gather up pitchforks and machetes, return and tear this guy apart, and then proceed to get back in line to vote. So I shared that story with my students this semester. Emma knew about this because she was in one of my classes. And I said, so, it's too confusing to vote. I don't have time to pay attention. I don't have time to go. Are you kidding me? People are willing to die for this right. People are willing to stand up for this right around the world. We need to do better. We need to do better. Now, we need to do better perhaps by encouraging ways for people to do better. So one of the things I'm very much in favor of, and again, I think there is a bipartisan or nonpartisan, however you want to put it, way, election day should be a national holiday. This should be an opportunity, and not like the national holidays where we have a mattress sale everywhere and people have all, opportunity. A true national holiday like Thanksgiving now is again. We got away from it for a few years, right? Stores are closed. Everything is closed except for essential services so that people truly have the opportunity, that we're focused on that. And what I've told my students, I said, you know how we can do this? We make this a national holiday. It's an election day. And that after you go vote, we create community volunteer opportunities throughout every community. So you go vote and then you go volunteer. You do something in your community to give back. Imagine what that would do for civic pride and civic virtue in this country. It would show that we actually care about people participating. We care about people collecting in their communities. And the reason I push this participation thing too is, imagine what that would be like. You go vote, which is a highly partisan thing, but then you come back to an organization and volunteer side by people who likely voted different than you, but are working in common cause for our community. What a better way to be a partisan and yet tie us back together immediately. So we need to do things like this. These are common sense reforms that we could take, again, that would benefit all political parties to do this.
We have a question from the chat. Just a
Yes.
minute.
Sorry.
So this is a question from Kathy. She says, we have a Supreme Court now that makes stuff up to come to the decision it wants. They have given the president the power to do pretty much whatever he wants. Historian Timothy Snyder argues that we are entering a supranational autocracy. Why do you think any law will protect voting rights going forward?
Okay, I'm gonna be maybe somewhat controversial here. I disagree with the fundamental premise of the question. And again, this is where people can disagree. I study the court a lot. I do not think that this court is a political court. I think that this court is made up of people who have ideological ideas. And we've seen this throughout the court's history, where people we have ideological majorities of one form or another. I know it's hard to hear, but I think that for the most part, the court is doing the hard work. Now, does this mean every member of the court equally is looking at the law and trying to uphold the law? That I think we can debate. But I think as an overall proposition, I think most members of the court are acting in good faith. The challenge is that with a lot of these issues, there truly are different legal arguments that one can make. And what happens often, and we see this in a lot of our Supreme Court discourse, is that we are so tied to the idea that we want to see forwarded that we forget that there might be a valid constitutional argument on the other side. And that's hard sometimes to stretch. Are there maybe perhaps members of the court historically, I don't even want to peg it to this court, that are more tied to their political inclinations than to ideological disposition? And when I talk about ideology here, I'm talking about interpretive methods of interpreting the Constitution. Sure, we can find outliers. But I think for the most part, the judges are acting in good faith. Doesn't mean we always have to agree with them, but I think the justices are acting in good faith. I'm familiar with Dr. Snyder's work on tyranny and autocracy. I understand the argument, but as I've told my students in class, if I truly believe that, I would give up doing what I'm doing, which is talking about civic engagement, talking about the republic, and trying to lift up people to do the hard work. If we're consigned to a certain path, then why believe in the greatness of what we have here to celebrate and to move us forward? Are there people out there that would prefer to see rule of man versus rule of law? Sure, we can't deny that. But again, that has existed throughout American history. That has been an ongoing debate from the get-go in terms of power, in terms of concentration of power, in terms of politics. We forget, we talk about how contentious our elections are, for example. Study the election of 1800 sometimes. That is a nasty election. It's been there right from the get-go. We've always had this in our DNA, but somehow we've always, as a people, been able to prevail above that, right? We've been able to rise above that with that common idea of civic virtue. So I don't mean to be contentious, but I think that there are possibilities for the court to take this seriously. It doesn't mean you're going to get the outcome you want. The Shelby decision, while personally I might disagree with that outcome, is founded on constitutional principles. It is not just the court saying we're going to make something up and do this because we favor one political party. I think it is much more complicated than that. And as good evidence of this, I would recommend reading Stephen Breyer's penultimate book on the power and authority of court. Now, here's Breyer, who was a liberal justice, who is articulating this idea that exactly what I'm saying here, that the court is, for the most part, made up of honest actors who are trying to uphold the rule of law, that are trying to uphold our Constitution. They just come at it from different perspectives. Yep.
Thank you very much. I think
Okay.
that's a positive ending for
Yes,
our
thank you.
democracy. Thank you so much. Oh, that was really, well, great articulation of the details behind that voting rights law. I appreciate that. So thank you all for coming. Thank you to the Waterfront. I think we all had a good meal again today. And Rob, we have a good video of this that we'll have on our website for later viewing as well. A few announcements. I always want to remind you that the book club is the last Monday of the month, and it's open to anyone. You can register on the website to keep up with updates in case there's bad weather. Our next Lunch and Learn is January 8th, and it's going to be titled United States and Wisconsin Constitutions Under Fire. So we're going to talk some more about elections and constitutional law. Emily Lau is a staff attorney at the State Democracy Research Initiative at the UW-Madison Law School, and she's going to be our speaker. Finally, I want to just say that this is the end of our centennial year. It's been great. I was looking at last year's agenda at this time and thinking about all these plans we had, and it's been a remarkable year. We've had so many volunteers and so much participation, so many important moments, remembering our league and the people that have started it and carried on through the years with all the good work. And so I just thank the people that did all that and everybody for the support. And I also want to remind us, people, that we did all these special things this year, intertwined with all the work of the nuts and bolts of registering people and educating voters on top of it for these important elections this year. So it's been quite a year. As we start another year, I am encouraged by the interest of new members that are looking to the league and want to participate, and the energy of our current members who are focusing on the mission and the challenges ahead and the opportunities that we see. Together, we're going to work and head right into the adventures of the new year, and I'm sure there will be lots. But thank you all for your support and participation, and we'll see you next month. Thank you.